And so, yeah, thank you for joining us, everyone, today. And this is our kind of semi-annual Zoom presentation of what we call your job as trustee, where other than our normal What's New in Estate Planning presentation that we do every year, we get asked pretty regularly from our clients when we're setting up an estate plan of what does the trustee actually do? So they get the idea of, who they want to name, but what are they actually tasked with? And so we came up with this presentation to advise either existing trustees on what their duties and responsibilities are, or even for our clients that are naming their successor trustees or executors of their estate, of really who would be the best person to pick. Because after finding out what the job is this something really you want to just, name, maybe your kids or a friend or a family member, just to have them do it, even though it's kind of a whole job to take care of. And so my name is Daniel Wilson, and I'm an estate planning attorney here. And our offices are in San Diego and Rancho Bernardo, North County. And we handle all types of matters of setting up an estate plan, such as doing your will and trust and power of attorney, all the way through and working with a trustee if a person becomes incapacitated and they need to take over, all the way through to after a death and administering the trust and distributing the assets. And of course, we handle probates as well and all those types of things. Let's see. And just a disclaimer, so this is general information for you. If you have any specific questions, you can always ask us. And yeah, this is our little disclaimer here.
And I'm Roberta Robinson. I'm the founder of Robinson and Wilson. I've been in practice apparently 44 years. And we are both certified specialists by the state bar in our field of law. And I am the proud mother of my partner, Daniel, here. And I've got five wonderful grandchildren. I never want to fail to include them.
And I'm also an attorney here. And again, we do estate planning, a certified specialist in estate planning, master of laws and taxation, and just try to be involved in the community here. And so with that, we can get started. Oh, and I'll say, if you do have questions along the way, you can put them in the chat box and we'll try to answer them if we can during the presentation. Otherwise, again, you'll have all our contact information if you want to send us an email or call us to schedule an appointment. You can do that as well.
So who are we really designing this seminar to reach? If I'm alive and I have a revocable trust, I can do whatever I want with that trust as long as I'm competent. So if I want to buy cryptocurrency, that's up to me. I can take all the risks that I want. I can keep changing things. I can decide who the beneficiaries are. But if I become incapacitated or upon my death, the trustee is held to a higher standard of care called the prudent person rule, a very, very high standard. The trustee is then taking care of the trust for other people, not for themselves. So they are held to what is called a fiduciary standard. They have to rise above their own needs and serve other people. If that person, the trustee, doesn't meet the fiduciary standard, they are in breach of trust and they can be sued. They can be removed. They can be personally liable for something that they've done. Professional trustees are trained in what we're going to be talking about, what to watch out for, what are your duties. So that would be bank trust departments and licensed private fiduciaries. But many times we're dealing with someone who's not a professional trustee, and it's important to see the road ahead because our experience is that the person who isn't the professional doesn't even know what they don't know. They don't know that there are critical things that they have to do and be aware of. And it's important to know it. You're always judged in hindsight after the fact. Someone would say, why didn't you do this? Why didn't you know that? And you were trying to do your best. So you have to see the road ahead. And what that means is when we initially meet with a trustee who's taking over, we're going to talk about everything that can go wrong. And you don't want to feel about that. You don't want to feel about what can go wrong. But your biggest protection to minimize your risk and your exposure is to actually think about the road ahead and what could happen. So we're going to go through the 18 points of the probate code, which are the duties of the trustee. The probate code tells us what are those duties, and we want to learn about them and see examples. All right, the first one is the duty to administer the trust. Well, duh. Obviously, I have to administer the trust if I'm the trustee. But you know what that means? I've got to find all the signed documents, not drafts of documents, the actual signed documents. And do I have the final signed documents? Should I be checking with the attorney who did all the drafting? Do I have everything? Because that is what you are bound to follow by law. And we need to see who really is the trustee. Sometimes we get a call on the phone, mom has died, I need a copy of the trust, I need this, I need that. And we go, wait a minute, we're going to pull out the documents to see, are we actually authorized to talk to you? Are you really the trustee of the trust? So that's an important position. We need to see what's the distribution plan. We have to follow it. Not that mom told me this is what she wanted, but literally, word for word, this is what the trust says. And it is important to consult with a trust and estate attorney, at least to get you on the right road. And that initial meeting is crucial, where we're meeting, we're looking at the road ahead, we're saying these are all the steps along the way. And we're also saying, do you think there's anybody who's going to oppose any of this? We want to cut that off at the pass, talk to that person, maybe get it cleared up.
And as far as what we call administering the trust, again, you can only, or the trust only controls the assets that are titled in the name of the trust or payable to the trust upon death. The trust doesn't just automatically control all the assets that you could have had, because if in the event of your death, you do have some bank accounts, investment accounts, or even real estate that's not titled in the name of your trust, so it's just in your name and you pass away, potentially those assets and those accounts would have to go through probate. Because again, if the trustee goes to the bank and gives a copy of the trust and says, I need to collect on all these assets, I need to get them under my control as the trustee, the bank would say, well, these accounts aren't in the trust. They're just in mom or dad's name. And so we're going to need maybe letters from probate court or something like that. And so while the client is alive and we're meeting with them, you'll notice that we always talk about your assets and how they're titled. Again, part of that is really just to make sure that in the event of your death, there is no probate and that we do have kind of the right style of an estate plan for you. And so that's also one of the first things we do when a trustee comes in that someone maybe has passed away or they become incapacitated. We have a handout that we'll give them, and it's basically just to fill out how are the what are the title of the assets. And so if for the house, do you have the deed showing that it's in the trust, or bank accounts? Do you have accounts, copy of the account statements? Who's on title to those? And so in the event that maybe there's some things that aren't necessarily in the trust, that's where we'll have to sort of change our mindset that we're maybe not just doing normal trust administration. We may have to do some collecting on the assets. And of course, the big deal is we really want to avoid probate court as much as possible. Again, being in California, every state has probate. California is a very expensive state to go through probate through. And also, it just takes a long time and it's public record. And so for most people, that's why they set up their trust, is really just to avoid probate. And so there are some ways to avoid a full probate. If, again, you pass away, there's certain accounts and assets that aren't in the trust. And this is where if the total value of maybe like bank accounts and things that aren't titled in the name of the trust, if they add up to a certain amount, anything below this threshold is passes without going through probate, just a couple of extra forms to fill out. That threshold dollar amount, it's actually just changed this month. It's now about $208,000. And so many people think it's like 100,000 or 150, and it's just been adjusted with inflation over the years. Now it's about 208,000. We have another new rule in California where, again, we have a lot of situations where, unfortunately, again, we set up an estate plan for someone, we put their house into the trust, we do the deed, and at some point they maybe refinance the property. Many years ago we had really good mortgage rates, and hopefully maybe sometime soon we'll get some good mortgage rates. But again, that causes a lot of people to do refinancing on their properties. Sometimes when you do refinance, the lender takes the title of the property out of the trust, puts it in your name because they want to know that you are the owner and they can lend, money against the property to you. And so in those situations, the property doesn't always get put back into the trust. And so we'll deal with these situations where, mom or dad did the refi, never thought about, checking title or just assumed it was always in the trust and they pass away. And now the successor trustee comes in and we pull a copy of the deed and say, no, was in the trust, but not anymore. It's just in their parents' name. And so there are ways to really avoid a full probate in those situations. And one of the newer tools that we have is if it's the owner's primary residence and it was valued at up to $750,000, there's sort of a simplified version of probate that you can go through. And of course, 750,000, unfortunately, in Southern California, it's kind of easy to get above that for fair market value of the real estate. But there are other options like we have on the screen. So again, it's just something important to always consider. How do you hold title to your assets?
All right, we're back to duties. The duty of loyalty. If I'm the trustee, who am I supposed to be loyal to? I'm supposed to be loyal to the beneficiaries, that I'm acting for their benefit. Now, let's say I never really liked my sister. My parents always favored her. She was always mooching off my parents. And my brother, I don't like his wife, and all these things, all these emotions that I have. I have to become aware of my biases and put them away because my job is to protect them whether I like them or not, whatever's happened in the past. So that's a big emotional hurdle for many people. What else could be loyalty? Well, my parents' house is very old. It needs to be remodeled. How about if I hire my husband, who's really handy, to work on that house and I'm going to pay him? Well, there's a problem with hiring your own family to do things. What if I want to hire my grandchild, who's the realtor, to help sell the house? That's a problem. There's appearance that you're not being impartial, and you don't know if you're doing the best for the trust. So we always recommend do not hire your own family to do anything. Go ahead to outside commercial sources and do your best deal with third parties to get things done. You can't not be hiring friends or family.
Yeah, and yeah, back to the Q&A. So, we'll try to answer some questions along the way. Some of them have to do with like the title to the assets on the slide before. And so just, yeah, general questions. So what about joint accounts? Do those go through probate? And they don't. So in the event you have a joint account with someone, so there's two people on title, in the event of the death of one of them, it just belongs to the survivor. And so if it's like a husband and wife and they're both on title jointly and it's not in the trust, one of them dies, doesn't go through probate, still belongs to the surviving spouse. Same if it's a parent and a child, again, it just belongs to the survivor. But you need to be cautious with joint account ownership because, again, just it doesn't mean it's really part of the trust and part of the distribution plan either. Because, again, if it's not titled in the trust and it's just a joint account, it belongs to the survivor. And then it's up to the survivor what they would do with that money. Kind of the same idea with accounts with beneficiaries on them. So if you have kind of the more classic one would be like a retirement plan, like an IRA or 401k. Those pass by designated beneficiary. So whoever you named on the account for it to pass to, that's where it will go. Same, you could do that with bank accounts and investment accounts. You would add a POD for payable on death or TOD, transfer on death, onto those accounts, again, with the financial institution. So the bank, you'd fill out their forms to name who would it pay out to upon your death, and those do not go through probate. And then, of course, yeah, what if there are some miscellaneous accounts that aren't in the trust and they add up to maybe more than that $208,000 threshold? Just those accounts do have to go through a version of probate. So it doesn't mean all your assets. So, like if you had your house in your trust, that doesn't mean your house has to go through probate. It's just those assets that add up to more than that threshold. Okay. So back on our duties. So similar to the duty of loyalty, there is also the idea of the duty of impartiality. So these are two separate duties in the probate code. And again, really, when you're the trustee, you have to be very impartial among the beneficiaries. You can't show favoritism. And that can be very difficult sometimes because many times the trustee is also a beneficiary. And this is a very common discussion that we have to have at the very, very beginning when we're meeting with the trustee, if they are also a beneficiary. So again, for the most part, maybe mom or dad name their kids as the trustee, and maybe, the oldest daughter is the first person in line, so that she comes in to see us as the trustee. And we say, well, we do represent you as the trustee. We don't even represent you as a beneficiary. Those really could be two different positions that you could be taking. So all the advice that we're giving you is in relation to you as trustee, meaning we're trying to make sure you follow the rules of the trust and also are minimizing your risk towards the other beneficiaries. And some examples of what could come up that could put this trustee in sort of a stressful position. Again, let's say mom or dad die, the trustee takes over, and now some people don't really understand sort of the timeline of how long it takes to administer a trust. And, even in the best case scenario, it takes a couple of months to get on title to the accounts, and you got to pay the bills and kind of maybe liquidate the real estate. And there's a lot of work to be done before the money goes out. Really, the distribution of the assets of the trust happens at the very end. 6 months, a year plus, it just takes a while. Some beneficiaries think that, mom and dad died on Friday, on Monday, I want my check. And so, it puts the trustee in a little bit of a position of stress to have to, get the money out or just keep saying, no, 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 we can't get the money out. But it is okay, within the rules of trust administration to do what we call a preliminary distribution. So before you do the big bulk, distribution of the assets, maybe it's just a certain dollar amount to someone that maybe kind of needs it usually. And normally when we're working with a trustee and they're considering doing a preliminary distribution, we would say, well, even if it's just the one beneficiary that's asking for it, just to be impartial, why don't you just give the same amount to everybody? And it just doesn't show favoritism, and it just shows, you're equal among everyone. And hopefully it takes the pressure off in the future of, maybe after the fact, one of those beneficiaries that didn't get the money if there was a partial distribution is getting upset when they find out about it. And another really big deal in being impartial is for ongoing trusts. So there could be a trust set up where I set it up for my spouse so that upon my death, my assets, maybe I had separate property, stays in trust for the benefit of my spouse. They have the right to the income as much as they need, principal within reason, but upon my spouse's death, then it goes to the kids. So this could come up in like a blended family situation where a husband and wife had children from a prior marriage. And now, the first person dies. They don't want to just give everything to the survivor because they could omit the stepchildren. So instead, they'll have these ongoing trusts for a spouse. And so in those situations, again, being impartial, normally the trustee is also the surviving spouse of that trust. They would have to think, well, I'm an income beneficiary, but there are also remainder beneficiaries, meaning who gets the trust assets upon my death. And so that's also a sort of a precarious situation to say for the surviving spouse as the trustee, are you being reasonable with maybe how you spend down and manage the assets of that ongoing trust? Are you also not just considering sort of what your needs are, but also what is supposed to happen with those remainder beneficiaries? And of course, all these other minor issues of impartiality can come up. A lot of the red flags or kind of issues that we see a lot is dealing with tangible personal property. So that's where, again, like the stuff inside of your house, family heirlooms, pictures, jewelry, clothing, furniture, just everything inside the house. Again, normally a trust, unless it specifically itemizes certain items to certain people or there's a letter, normally the trust just gives the trustee the ability to give it out among, a certain group of people, usually the children. And in those situations, it is difficult to be impartial because now you're thinking, well, this isn't, mom's wedding ring. It's not something that really can be divided or that. And so that's a very tough situation for many trustees to be in, is to make the decision of who gets what of the personal items. And for all of our living clients that are paying attention, you can be the one to decide who gets what versus leaving it up to the trustee. And so if you ever want to put together like a letter, or even within the trust itself, list certain items to certain people, especially if those items would cause conflict, if it was just left up to the trustee, you can be the one to decide. And then it takes, again, the pressure off of the trustee to decide who gets what. Another issue of impartiality, and these are just things that keep coming up in our world, is again, we're seeing a lot of, I think they're called multi-generational households, basically where the parents, own the house, and one of the kids, usually like an adult child, is still living there. And so that could be, again, a difficult situation, even if they're the trustee or somebody else is the trustee. What are you going to do with someone living in the house that's, part of the trust that's maybe meant to be divided among three people or should be sold and divided among the three? A lot of times the issues comes up of, well, do you have to charge that child rent? So maybe when mom and dad were there, they didn't because that was their decision. It was their house. They could decide whether or not they rent it to their own child or not. But once they pass away and the trustee comes in, they don't really have the authority to just let that person live there rent free for forever. And what if, they charge less than fair market rent? Again, is that really being impartial among the other beneficiaries? So these are all issues that come up somewhat regularly nowadays with us when we're advising a trustee.
There's a duty to avoid a conflict of interest. Sometimes when you're in the soup, you might say it's hard to recognize that you do have a conflict or the appearance of a conflict. Uh, and what we're worried about is as trustee, you cannot personally profit from the trust. If the trust says you are going to receive reasonable compensation, or it might say 1% a year, or it might say no compensation, the trust guides whether you're entitled to compensation. That is one way that you might say, profit from the trust. That's allowable, and your out-of-pocket expenses can be reimbursed to you. And that would be postage, mileage, if you're out of the county flying here to take care of things, but not for your whole family. It's not going to be reimbursing anybody but the trustee. Well, what if the trustee says, as Daniel was saying, I need to live in the house, I'm going to keep it safe. Well, are you acting for your own benefit? Are you profiting from living in the beautiful Coronado house right on the beach? That's a great place to be. Or should it be rented to a third party who pays fair market value rent? What if you borrow from the trust? I had a big case where somebody borrowed $250,000 out of a trust, invested it in something else, and later paid back because I said you better put it back, put back $250,000. And I said, what happened to the investments that you made with the money? Oh, they tripled. I just did great. Well, guess what? And upset beneficiary can go after all the profit that you made with the money that you borrowed. So you can't personally be dealing with the trust. You shouldn't be selling or buying anything from the trust either. You should not act as the broker on the real estate transaction. Even if you are a broker, hire somebody else. You cannot profit from it. Daniel, let's go on to the next duty.
Okay. And so this is also kind of a fun one that we get to tell the trustees, usually towards the end when it's time to do the distribution. So let's say they've done all the work in administering the trust, and now it's time to actually get the assets to the beneficiaries. One of the things we can do is request that a beneficiary sign a receipt and a release agreement saying, I got what I'm entitled to from the trust, and I agree I'm going to indemnify, I'm not going to sue the trustee, and everything, I got what I'm entitled to, and everything was done fine. Sometimes trustees say, well, why don't we just have them sign that before they get the money or before they get the distribution? And in California, very specifically, there's a duty that's all by itself that says you cannot require a release of liability as a contingency on getting the distribution. And so again, some trustees feel like they are the ones that have all the power because they're put in charge of everything, but they really are beholden to the beneficiaries and must do right what's by them. And so again, a beneficiary can't be forced to release their rights from the trust that the trustee would get or the trust would give them. And so again, normally we can always just submit or these release agreements to the beneficiaries, and sometimes they can sign it. They don't have to. Normally, again, you can always have a record that they actually receive the asset. So even if they're unfortunately not willing to sign a release or even like a receipt, again, you can still show that you have the record that they received it. And ultimately, in really everything that we talk about today, we're talking about like sort of privately administering a trust, meaning you're just following the rules of the trust with the probate code and following what the trust says you're supposed to do. If things go wrong, you can always go to court. So unfortunately, again, if the trust administration is just not going as smoothly as it should be, and the trustees may be worried about some beneficiaries suing them or kind of anything that could go wrong. The trustee always has the right to go to court for approval of their actions. And of course, that sort of delays the overall timeline of the trust administration and has a lot more expenses to it. but it does provide the trustee some finality and some protection in case once they do the action that a beneficiary can't come back later on and, complain about it. And that's part of when we're working with the trustee is saying, okay, we'll do this release, we'll receipt, all these agreements and everything when you get the assets out. But why don't you hold on to a little bit of money just in case something goes wrong? Either definitely for like future expenses of filing like the taxes and things like that if you still need to do that. But if there's a concern that a beneficiary might try to come, sue you or hire an attorney afterwards, you want to have a little bit of money on hand to sort of defend the lawsuit.
Here's our next duty, not to serve as trustee of an adverse trust. Well, what does that mean? If you've been asked to be trustee or you are trustee of more than one trust, you have to look at each of those trusts to see who are the beneficiaries of the trust. Is it possible that these beneficiaries are going to be in conflict with each other? What's an example of that? In a second marriage, the husband may have children of a prior marriage, the wife has children of a prior marriage, and you're asked to be trustee of both trusts that are going to different beneficiaries. And let's say the husband and wife's trust own a home together. Well, what could possibly come up that would be adverse? Well, let's say, I'm going to say the husband's children say, I want my money right away. I don't care if it's a good real estate market. I didn't work for this. Just liquidate it and I'm going to get what I get. And the wife's side says, wait a minute, that property's been owned for so long and we really have an emotional attachment to it. And let's keep holding it until there's a better time to sell. So now they're in conflict over when should the property be sold. And if you're the trustee, you're the person that has the power of sale. So you want to avoid these situations where there could be adverse interests. It would be better that there are two separate attorneys for each of these trusts. It is possible to get the written consent of all the beneficiaries that you will represent all of them. It doesn't mean there aren't going to be people complaining along the way, but they could consent to it. So they're consenting that you're serving on both sides, but you could be putting yourself in a dangerous position. So you want to think about this before you become the trustee. And many people feel, oh, it's such an honor. I've been named. This person is relying on me. I say, pause, take a breath. Let's look at the big picture here. And is it an honor or is it a big burden? Let's analyze it first. Daniel, back to you.
Yeah, so that's something we do again in the very first meeting after a meeting after like a client passes away and we're meeting with the successor trustee. That first meeting is very important to really kind of lay everything out on the table to figure out, is this something that this person that's named as the trustee, do they really want to do it? Again, no one has to act as a trustee, so they always have the right to decline to do it, or even if they've accepted the role and they're starting to take it on, but then they have a change of heart, they could resign as trustee. So again, that's something that we highlight in the very beginning is this something that you really want to do? The next duty, and this covers quite a bit, is what's called the duty to control and preserve the trust property. So one of the very first steps after someone passes away is normally we tell the trustee, sometimes we get a call like the same day when someone died, and they just said, mom or dad said, as soon as I pass away, call the estate attorney. And then so we'll sometimes get one of the very early calls, and there's usually not a whole lot that needs to be done in the first day or the first week, especially because the trustee can't really do very much until they get the death certificates. So normally you would order the death certificates through the mortuary, and you get, 6, 10, 12, 15, however many would be a good amount to get. And that really is what starts the trustee's ability to start controlling the trust property, meaning getting assets and things under their control as the trustee. So sometimes the first step, again, when someone calls us, is we'll send them that handout to fill out, basically getting a list of the assets and liabilities. And in reviewing the assets, we also really want to highlight and make sure, how are things titled? So we talked about that before. Is it titled in the name of the trust? Is it jointly titled? Is there a beneficiary on it? Is it just titled in the person's name individually? So as an example, because there are some assets that do pass outside of the trust. Kind of a simple example would be like retirement plans, IRA, 401k. those are never really owned in the trust in the person's lifetime. So the owner is the person, the employee, the participant, and then they name a beneficiary to say who does it pay to upon their death. The trust could be the beneficiary on the retirement plan, or it could be a spouse or children or charity, whoever it is. Again, those assets pass outside of the trust. Same if there's like a POD or TOD on an account, it means it's not really not owned in the name of the trust. It pays to someone, which could be a trust, after death. And so once you get a list of the assets and liabilities, another huge step is getting appraisals and valuations of those accounts. So bank accounts, very simply, I mean, if it's just cash, you just get the monthly account statement for that month. If it's an investment account, so there's stocks and bonds and securities and things, you would get what's called a date of death valuation. And so pretty much any financial institution, you would just tell them, once you get the death certificate and you get on the accounts, you could say, okay, give me a date of death valuation of this account. So they just plug in, May 8th, 2025. This is the value of the assets on that date, and that becomes the valuation that you have for the investments. And also, you would want to get that for income tax purposes, which we'll talk about too. But you do, and then for all the real estate, we do recommend getting valuations for the real estate. Depending on the situation, the trustee either is going to get a formal appraisal. So you would hire an appraiser to come and go through the house and come up with a very solid number based on the condition of the property. Other times, it may be that you would, instead of getting a formal appraisal, you can get just a valuation from like a realtor, and you can get what's called a broker's opinion letter. And basically, it's a realtor saying, based on comparable sales, and maybe give a list of those sales around that time. This is the value of the house. And so it really depends on the situation whether you're going to get a formal appraisal or the broker's letter. Normally, if the plan is to like sell the property within about 6 months after the date of death, you may not need to necessarily get a formal appraisal of the property. Another big deal of dealing with the assets is maintaining insurance on them. So, of course, the biggest one that we're thinking here in Southern California would be homeowners insurance. So, of course, we're worried about fires and we have good reason to be worried about them. And so that's always one of the main issues we bring up when we see real estate in working with the trustee is there a good policy? How long is it in effect for? Normally, the policies are maybe 6 months or a year at a time. When do you need to renew? Does the current policy, is it really effective? Meaning, if the property is no longer owned or occupied, maybe by the resident because they've passed away, does the policy still pay out? So, worst case scenario is, I have my house and I have my insurance and it's good while I'm living, and then I die, my kids take over as trustee, and now the house burns down or something, or they're showing it to potential buyers and there's a slip and fall and someone gets hurt, and now they're going to try to sue. Is the insurance going to pay out? I think we all have the concern that, insurance, their whole game is to try to deny coverage. And could they try to deny coverage because the house wasn't adequately insured? And so that's a big thing is we always want to highlight is make sure you get a copy of the policy or at least talk to the representative for the insurance carrier to make sure that, you're covered. And if you need to renew, what's your timeline and what's the date for renewal? Uh, Again, big topic is preserving the trust assets. And so part of coming up with making sure you know what all the liabilities are is you can also get copies of prior tax returns. So you would get an idea of have they filed tax returns in previous years? And if they didn't, did they need to? And also it helps with going through the tax return to find out what are the assets. Again, some people, very simple estates, they just have their house, bank account, retirement. Everyone knows where, they use the certain banks and it's not a surprise. Other times, mom or dad could have various, credit union accounts in different states, lots of real estate, lots of investments, and maybe there's a life insurance policy that they really are kind of having a hard time to track down. Going through the tax returns is also somewhat of a good place to check to see maybe are there other miscellaneous accounts that they received interest or dividends from that would help you sort of locate where those assets are. And again, we talked about the first step is getting the death certificate and giving out to those institutions to get the assets under your control as the trustee. And at the same time, you would also have to re-register those accounts to be under a new tax ID number. So on the screen, we call it the federal identification number, sometimes called an employer identification number or taxpayer identification number. Basically, it's a social security number for the trust. So again, while you're alive and it's your own revocable trust, all of the assets are registered under your social security number. So that's why it's like the trust in a way doesn't exist in your lifetime while you still file your taxes the same, kind of it just exists in the background. But once you pass away and the trust becomes irrevocable, the trustee needs to get a new tax ID number, usually from the attorney or the accountant to just apply for it through the IRS, either online or by mail. And then that's part of re-registering and getting the accounts under your control as the trustee is using that new tax ID number. And of course, again, being in Southern California, most of our clients, big concern is real estate. And so there are certain deadlines that you have to follow when filing, reporting a death of somebody that owns real estate in California. And the big thing is really, is there going to be a change of ownership? So are the property taxes going to get reassessed? Unfortunately, there's sort of a new regime in property tax law in California that says after someone passes away, that date is considered the change of ownership date. So it doesn't matter if the trust owned the house for like a month or year before it actually either sold it or transferred it to the kids or something. The date of death is the change of ownership. So that's where the assessor is saying this is the date we're reassessing the property taxes. So whatever the house is worth on the date of death, that's the new property tax is based off of that unless an exclusion applies. And there are various exclusions. The main one that we talk to people about is if property is going to from a parent to a child. And without getting into the details too much, there is the timeline of filing certain forms with the assessor's office within a year after the date of death. So that's a very strict period. And believe it or not, sometimes it takes a little bit of time to administer a trust. And even dealing with it, some people, we don't get calls, like I said, sometimes the day the person dies, sometimes it could be like 6 months later, or sometimes never, because they didn't really need to do anything until someone told them they need to do something. And so, yeah, it's just important working with, again, an estate attorney to tell you, these are the forms you need to file, these are the deadlines, and all of that. And of course, sort of higher level issues and in being a trustee for like ongoing trust, if it's not sort of the normal, just liquidate everything right away, distribute the assets, equally among the kids, done within 6 months to a year, there could be ongoing trusts or trusts with lots of like an ongoing business or real estate, rental property, apartment buildings, all these things, and the trustees administering those assets within the trust under the terms of the trust. But again, the trustee has to really think about liquidity planning, cash flow, money coming in, money coming out. Again, if there is a change in the property taxes, do they need to adjust the rent or can they continue to afford to maintain the property? So when you have sort of more sophisticated assets for ongoing trusts, it's really important to consider, do you have the right trustee that can really plan and see all of this, in the very beginning, because they don't want to be playing catch up and just, kind of fix mistakes as they come up.
Very good, Daniel. That was a huge amount of information to cover. Our next duty, to make trust property productive. What are we talking about there? Many trusts go on for quite a long time. One trust could be a trust for my spouse for the rest of his life, and at his death, everything goes to the children. In that fact situation, my spouse is the income beneficiary, and my children are the remainder beneficiaries. They get what remains. Well, the income beneficiary wants as much income as possible. They may not care about the growth of the principal. The remainder beneficiaries want growth because they're going to inherit one day. So you can see that sometimes what the income beneficiary wants and what the remainder beneficiary wants might be opposing things. As trustee, you have a duty to all these beneficiaries. You have to protect all of them. So you have to come up with an investment policy that balances out the interests of the income beneficiary and the remainder beneficiaries. So sometimes you'll see an investment policy for securities, particularly that says, 40% income, 60% growth, and every year they kind of rebalance and see where are they at. There could be raw land involved. And in that case, what is it producing for the income beneficiary? Nothing. And in certain trusts for a spouse, it says the spouse has the right to demand that the assets produce income. So you have to think, at that point, what am I going to do? Were these investments, they might have been good for the person who created the trust, but are these appropriate investments for the beneficiaries who I'm dealing with now? And in many, many cases, the investments did get a new basis at death. All capital gain on many investments is wiped out at the death of the owner, so the trustee has a fresh start and can possibly sell without gain various investments and get them reinvested to serve the purposes of helping these beneficiaries. And what's new this year is we are in a very volatile market, extremely volatile market. And if you were taking over as trustee right now, what would you do? Would you liquidate a stock portfolio immediately because you don't know what's going to happen next week? Would you say, well, wait a minute, I've got 6 months, maybe 9 months till I have to make a distribution. Maybe I should ride it out for a while? Would you sell and invest in very, very conservative investments? So we're dealing with a very volatile market. The trustee now has extra risk because of the market that we're in. So we can't ignore that this is a big factor that today's trustee has to consider.
Yeah. And hopefully, again, for everyone that's thinking for their own estate plan of who they name as their own trustee, you're thinking, are the people that are in there now or who you've named, are they still capable of the job? Typically, when we're working with someone, we advise, let's name a primary successor trustee, maybe a backup just in case. You could have as many people as you want on there. So you could have 5 different people in order to act as trustees, just in case any one of them doesn't want to do it. Some people will put like what's called the private professional fiduciary that Roberta mentioned. So this is somebody that you name by name, but who's licensed and to act as a trustee for others and insured and bonded by the state and everything. But there are situations where what if people that you've named in there aren't around to act as trustee? And so that's what we would call a vacancy in the office of trustee. So everyone you named either isn't around or doesn't want to do it. First, you would look to the trust to see what happens if there's a vacancy. The trust would control sort of the procedure. It could say that the beneficiaries can appoint someone. So that might be an option. If no one kind of named wants to do it, the beneficiaries, hopefully they can agree on naming one of them or an outside party to be the trustee. If they aren't going to agree or the trust doesn't really provide for the right sort of simple procedure, that somebody would have to go to court to be appointed as the trustee. So right, ultimately kind of the court is sort of has the right to sort of kind of name the trustee, but normally it's whoever wants to do it would petition to have themselves become the trustee. Okay. Now, again, some other duties that, believe it or not, this is one that can hopefully whoever's acting as trustee is very conscious of at the very outset. But I've been surprised before myself where some trustee thought, oh, I'm the trustee. I'll just put all the accounts in my name. So really, they're in a way stealing all of the trust assets and putting it under their control. That's normally not their intent, but it has the same effect. And if they were ever in front of the court or a judge or again a beneficiary's hired an attorney, and they see that the trustee just put everything into their name, like bank accounts and things, I mean that's just a kind of an easy situation to have that trustee removed because that's a very large breach. So kind of the duty that we have to avoid that is what's called the duty to keep the trust property separate from your own. So again, just because you're named as the trustee, it doesn't make it your assets. It's still the trust's assets. It's just the trustee has the ability to sign on them. So they're the ones signing on the bank account, signing on the house, things like that. But they don't actually have ownership. And just in case it's sort of not understood that way, uh, a trustee doesn't also isn't always the beneficiary as well. So you could have a trustee who is not a beneficiary of the trust. So again, they just have the ability to sign and deal with the assets of the trust. And so that's just something that we always want to remind people that again, when you're getting under the trust assets under your control, it's still with your name as trustee of the trust and keep the accounts registered under that tax ID number for the trust ID number. It's not going to be under the trustee's social security number.
As trustee, you have a duty to enforce claims, What does that mean? If money is owing to the trust, and it hasn't been paid, you have a duty to go out and collect it and possibly sue to get it. So, what do we see that is an uncomfortable situation? One of the children borrowed money from dad, and that money is still owing back to the trust, and the child hasn't paid. The trustee, who could be that child's brother or sister, has to say, you have to pay this money back, and let's make arrangements for the repayment. What if the child says, well, I don't have any money to pay it back? The trustee could say, well, your share of dad's trust is going to include the money that you owe. In other words, you're going to inherit your own debt. You're not going to get that much because you owe money back to the trust. What if the child owes more than their own share? And that could happen where they haven't paid on it in a long time. At that point, the trustee could decide to sue the child to collect other assets, or there could be a negotiated settlement of sorts that the note will continue to be payable to the other siblings. That's a doozy because now the siblings have to try to collect from their brother, but that's a possibility. But the note doesn't just go away. And as trustee, you don't have the power to say, well, let's ignore it. I don't want to think about it. I understand you're in a tough situation, even though it's a family. The trustee does not have that authority. I'm handling a case right now where I told the trustee if all the beneficiaries agree to forgive the son's debt, we could go to court to modify the trust and ask the judge to basically write off that asset or that note. But you, as trustee, do not have the authority to forgive it. And in this case, I think 8 out of 10 of the beneficiaries agree to forgive it, but 2 of them don't. So it's still problematic. So it's a tough position to be in, but that's your duty as trustee.
And while, again, if you're alive and you're the one maybe loaning the money to your child or someone else, how can you avoid these potential conflicts in the future? Is really just kind of we can put it into the body of the trust, or you would let people know either this is a gift, it is a loan, it's an advancement against the inheritance, and we can write all that into the trust. We can have a simple sentence that says, any money I've given to my kids shall be forgiven and not count against their share. Nice and simple. It doesn't matter how much they give unequally among the kids. Clean slate when I die, just make it equal. I don't want to deal with the headache of having to rebalance it. Other times, again, if the person thinks that would be unfair, they could say, I'm going to, the first $200,000 from that one, goes to the other two kids. The one that I gave the 200,000 to in their lifetime, they got it. So my other two get 200 off the top. The rest is divided equally among the three of them. You could do that. We could even, if it's in the situation where there's an ongoing loaning of money, and I don't know if it's really considered a loan if you know you're never going to get paid back, but if it's an advancement against their inheritance, the trust could say, I'm going to keep a record of it. And you would keep your own private record of just saying, in January 2025, I gave $10,000 to my son. March 2025, I gave $15,000 to my son. And you just keep this record. It's just like a ledger. And those are assets of your estate at your death. So the trustee can come up with this list and say, okay, we're going to add it all up, charge it against each person's share, nice and clean, nothing to fight about. And again, by you keeping the record, you can say, well, the $5,000 that we spent gave him to go on vacation for, that's not an advancement. That was just a gift. And so again, you can be the one keeping track of all that versus the siblings having to figure it out and sort of fight out about it afterwards. And speaking of fighting, the trustee also has a duty to defend actions. And so there could be these situations, and it's come up before, where maybe there's a lawsuit that was pending against the parent, in their lifetime. It could even be a divorce. I'm still surprised when we find out that we have sort of our more senior clients that are going through a divorce and have passed away even before it's finished. And now the successor trustee has to be the one to sort of step into their shoes to finish that. Or again, what if, there was a car accident that the person's being sued for, they pass away. It doesn't just go away because someone died. The trustee still has to defend those lawsuits. And a lot of it would have to do with, if there's any creditors as well. So unfortunately, again, there's situations where, especially in San Diego, it's a very transplant type of city where we have, many of our clients that live here, but the family and the kids or whoever just are beneficiaries are all spread out around the country or the world, and maybe they don't know what the assets or they don't know what the liabilities were of the person that passed away. And so there is a very specific process you can go through to notify any creditors. It is going through probate court, but it's not like opening up a probate. It's kind of a one and done type of thing where you say, I'm worried there could be creditors coming forward. Again, as the trustee, you're the only one at risk. So if all the beneficiaries are saying, there's no creditors, don't worry about it, just give us the money, you give out the money, and it turns out there are creditors that you could have known about, they could try to sue you personally. Again, because they know they're probably not getting the money back from the beneficiaries, but they're likely going to sue the trustee to be personally liable for those things. And so the way you can avoid that, to be extra cautious, is by the trustee going to court and following what's called a notice to creditors process, where essentially you publish notice in the paper, you give notice to all known creditors by mail, and then there's a hearing date, or essentially there's a 4-month period for them to file a claim against the trust or the estate. If they don't file anything, they're barred from doing it in the future. So again, it protects the trustee from any unknown claims that could come up. So we don't do it very regularly, but it does come up every once in a while.
Then we have the duty not to delegate, the duty to supervise. I call it the buck stops here law. So you might remember President Truman had a sign on his desk, the buck stops here, meaning I can't make excuses that I didn't know about it, I didn't supervise it, I didn't do it. The trustee is responsible for what happens to the trust. The trustee can hire people to help, which always makes sense. An estate and trust attorney, a CPA, a broker or property manager to handle real estate, a handyman to make repairs. The trustee can hire these people, but they can't get rid of their duty to supervise the trust. So that means as trustee, you must supervise everyone who you hire. Make sure you keep track of all the deadlines and who's working on what. You have to be squeaky clean. And you can be held liable for the negligence of the people that you have hired or that they have failed to do something. You're not going to get out of it. So the buck stops with the trustee.
And a very common question we get is, can I just name all my kids as trustees? So can they be co-trustees? And then your attorney's going to sigh and say, yes, technically you can, but we don't recommend it. I'll say I'd be hard pressed to believe that any estate planning attorney would recommend naming co-trustees just because there's so many things that could go wrong. And we'd rather it go wrong with one person making the decision versus two people making the decision. Because again, if they have differing opinions, nothing can get done and it slows everything down. We always say, even in the best case scenario, if everyone does get along, still it could be a bit cumbersome. Some banks actually make the co-trustees go together at the same time at the same branch, which really makes no sense these days, but some banks do that. And so, of course, if you do decide to name co-trustees, they still have all the responsibilities to even supervise each other. And there's no, shared or there's no sort of separating the liability. It's all completely shared. So if, my brother and I are co-trustees, he does something wrong, I could still be sued as a trustee. And another big deal also has to be, or should be, whether about the compensation. So we'll get into more detail about the trustee's fee or their compensation to act as trustee. And just because you have two co-trustees or even more, that doesn't mean it's like doubling the fee. In a way, it's the same fee that they're sharing. So not a huge benefit to act as a co-trustee either, because now you're having to share a fee. Even if one person's doing all the work, I mean, they could, between themselves, they could decide, oh, you did 75% of the work, so you get 75% of the fee. But again, it's the same fee that a single trustee would have been able to receive. And of course, even just practically, there's some issues with naming co-trustees that some banks and financial institutions won't even allow it. So we're starting to hear, I won't name any banks, but some of the some big banks that you would have heard about, if there's a co-trustee, they won't allow that at their bank, meaning they'll say either one of you has to resign. So now, and that is an all or nothing thing too. You can't just say on this one account, I won't be the trustee. You would have to resign over the whole trust estate. or you would have to like move the accounts to another bank. So again, there's just some issues with having co-trustees, but you are allowed to do it. Um, yeah.
Here we have two brothers who look remarkably like each other, but obviously have different backgrounds, different levels of education. If a court is ever looking at the activities of the trustee to try to make a determination, was it a breach of trust? The judge will consider the skill level, the educational level of the trustee. So, not to be biased, but the brother on the right, if the brother on the right says, I don't understand accounting and taxes, and I don't really read contracts that much, I just sign whatever was put in front of me, the judge may sigh. I like Daniel talking about the sigh. But the judge may say, I can't hold you to a high standard of care. You're acting on things of which you don't have that much knowledge. I'm going to hold you to a lower standard of care of a lay person. And then I've got the doctor on the left. And the doctor says, oh, we sold the house. I never read the listing agreement with the realtor. I didn't read this. I just signed it. They gave me papers and I just signed it. And the judge would say, well, too bad. I'm holding you to a higher level of care. You're a highly educated person. I'm expecting that you do read what you sign. So it could be that someone who is more highly educated has greater exposure to liability. And you want the best job done, but you need to know that the judge will always be looking at who is the trustee. And if it is a professional trustee, you better believe the judge is expecting the highest level of standard of care.
And still more duties. Again, this is really everything that we as like estate planning attorneys have to think about and convey to these trustees that these are all their responsibilities. It's not a really simple job. There's a lot to it. One of them is what we call the duty to keep beneficiaries reasonably informed. And so this is a very sort of unknown rule in California that says, again, when I create my trust, it's a revocable living trust. It's a private document, just me and my attorney have it. No one ever has to see it. And I can change it whenever I want for the rest of my life. Upon my death, let's say I'm a single person and my trust becomes irrevocable because now I'm gone, no one else can change it. It's an irrevocable trust after I die. The trustee now has a duty to notify the beneficiaries and my heirs about the trust. So there's a very strict rule in California that says when the trust becomes irrevocable, the trustee has a duty to send out this notice. And basically, what it's saying is now, here's the information about the trust. I'm the trustee. Here's my contact information. And then there's big, bold language on that letter that says, now that you've received this notice, you have up to 120 days to contest the terms of the trust. So very specifically, that means after it's sent out, they have 4 months to sue essentially the trust if they don't like what it says. And so that's the situation where normally we try to get those notifications out as soon as possible. We want to get that clock running because we're going to tell the trustee, don't make any distributions until after the 4 months has run. So again, you can still pay bills, liquidate assets and things, but don't pay don't get the money to the beneficiaries until we know no one's going to contest anything. And who does it go to? Not only the beneficiaries of the trust, so that would be, the people that are going to inherit through the trust, but also my heirs at law, which could be different. So let's say I have 3 children and I've omitted one of them. So they're not in the trust anymore. Everything's going 50-50 to the two. That one I've omitted is still my heir at law and is still entitled to receive a copy of the trust and that notification. So when these notifications go out, the trustee typically is going to send a copy of the trust along with it. And sometimes not only is it just the final copy of the trust, but if there's been amendments along the way, the trustee may also be sending out these amendments. And so that kind of is a surprise to a lot of our clients when we tell them this part of the process that they don't want the previous versions of the trust going out, but these beneficiaries have these rights. There are ways to sort of avoid that. Some people will, if they don't like the way the trusts were done before, what was in there, because it was maybe a tumultuous family situation, if they sort of close out the old trust and create a brand new trust, it's a little bit of extra work, but it avoids the issue of having to send out old copies of the trust or old versions of it. And not only do we have to send out that notice to the beneficiaries and the heirs upon my death, but there's a relatively new law that says it also has to be done if I'm alive, but I become incapacitated. So in California, I'm alive, I become incapacitated, my successor trustee has to take over, maybe get like those two doctors' letters that a lot of trusts say for the successor to get involved. That's also a triggering event for sending out a copy of the trust. And unfortunately, a lot of people don't like that because now you're thinking, well, I'm alive, and already these people are going to be notified about the trust and what it says, and we'll talk about it, but they also get a right to know what are the assets. So that is a new law, unless this is the only time you can opt out of it. So in my trust, I could say, upon my death, yeah, they have to send the notice to the beneficiaries and the heirs. But if I'm alive and incapacitated, no notice has to be sent. So I'm opting out of that rule. That's one of the few times you're allowed to do it is if you're alive and incapacitated. And so, like, let's say you have maybe just your assets going to charity. So great, don't worry about beneficiaries and heirs getting upset about anything. It's just all going to go to charity. But I don't want the charity to know, what the trust says and how the assets are being managed and what they're going to get. Because I'm still alive and I could be living for many, many years. I don't want the charities to have to be notified of this. I could opt out of it. Again, it doesn't have to be charities. It could be your own kids or anyone that you don't want them hassling the trustee to say, why are you spending down my inheritance to help take care of, mom or dad? But again, if there's no duty to notify or account, then they don't have to do it formally. And even along the way, when we talk about keeping beneficiaries reasonably informed, not just in these formal ways of sending notice of like the trust and everything, but also if a beneficiary just has a general question, the trustee has a duty to respond to it. So if there's reasonable requests for information, the the beneficiary wants to know what are the assets, not how is everything being managed in the exact balance, but you could say there's X amount of dollars here. We're dealing with the real estate. We're going to put it on the market in a few months. They have a right to request it, and the trustee has a duty to respond to it. So again, sometimes trustees get sort of this, bit of a God complex to think, oh, you'll just get whatever I tell you you're entitled to. But no, the trustee, is sort of working for the beneficiary in a way. And not only are we thinking of the notification, but also there's the duty to keep them informed about the accounting. So again, upon my death, my trust becomes irrevocable, trustee steps in. They do have a duty to account to the beneficiaries. So they would have to show at some point, these are all of the assets as of the date of death. So these are the bank accounts and their values, the real estate and the appraised values, all that information with what you started out with. Then you have a list of income. So interest, dividends, rent, sales proceeds, gain, loss, all that goes on this accounting record, along with a list of the expenses. So every single expense to the penny. So, I paid for movers to clean out the house or a storage unit. I paid the attorney's fee. I paid, the realtor's fee, the commission, just postage. Everything goes on this accounting record. And finally, you have what's left on hand. And once this accounting is given out, normally it starts a period for the beneficiaries to also object to the accounting. So again, there's the 120 days to object to the trust. So what does the trust say? Separately, once an accounting is given out, there's a separate period for the beneficiaries to object to really the trustee's actions. So what they did during that period of accounting. And that period to object, it's really dependent on the trust. It could be as short as 180 days from the day you send out the accounting, or even up to 3 years. So again, potentially the trustee could be on the hook for 3 years, even after, they've settled everything, maybe they've distributed the assets. There could still be, 2.5 years go by, a beneficiary could come back and say, oh, I don't like that you sold the house for, less than what it's worth now or something like that. So again, there's a lot of information that the trustee has to be responsive to the beneficiaries.
Ah, this is my favorite slide. I get to do the pictures. I have so much fun. So you're the trustee of a trust. It's an ongoing trust. And you're deciding, should I pay money out to the beneficiary for this? Should I pay money out for that? What do? We look inside the trust to look for the paragraph or paragraphs that say what authority you have to make distributions. And in a really long, thick trust, it could be that these critical paragraphs are pretty short and they're on page 30. So, but we have to find that language because that is our guide for what are we allowed to do as trustee. Always the trustee has to act reasonably. What if the trust says, trustee, here's common language, trustee, you have authority to distribute to little Sally here for her health, education, maintenance, and support. So that's your standard. So if Sally comes to you and says, I need money to get a vacation home in Mexico, is that going to be for her reasonable health, education, maintenance, and support? And it's very interesting how a beneficiary thinks they need something and the trustee thinks that they want something, but they don't need it. So you have to see what is the standard. Your standard might be that you have absolute and sole discretion what to pay out. So that's very broad. Does it mean that you get bossed around by the beneficiary? No, you have to act reasonably. You have to say, well, what is this trust for? Am I trying to support little Sally here for the rest of her life? Or it needs to be distributed all when she's 30? How long am I supposed to make this trust last? And in today's times, if you have, a 25-year-old beneficiary and it's supposed to last their entire lifetime, we're talking about a huge amount of money that's needed just to give them reasonable monthly support. So you may think, oh my gosh, this trust is $5 million. But when you think of how long it has to last and provide for this person, you might be very cautious in the distributions that you're making. Also, the trust might say income must be distributed to little Sally. So you have a duty to keep track of what is the income of the trust separate from what is the principal. And the income would be interest and dividends. And from a rental property, net rent after payment of all the expenses. But if you've just sold some Apple stock at a huge gain, that actually is trust principal, even though we think of it as income because there's a capital gain income tax. But the goose that lays the golden egg, the actual core of the trust is principal and is not distributable as income. So you have to keep track of this. It'll show up in your accounting. You might think, how am I supposed to know this? Well, your CPA will know it. Your attorney will know it, will get you set up correctly. And every year you'll probably meet with your CPA to see what is the net income of this trust, especially near the end of the year, because if you have to get it all out, you really have to know what is that number. How much have I already paid out? Do I have any excess income that I need to get out this year? So there's a lot to keep track of. And I like to say, I don't know that I like to say it, but as a trustee, you are the ultimate parent. You're trying to decide what is in the best financial interest of that beneficiary. Is it to be generous? Is it not to be generous? They should grow up and become productive and get a job. You're the ultimate parent as well as having to do all this accounting. Because you will be judged in hindsight for what you did, maybe years after it happened. It's important to keep a written record of your distributions and your discretionary distributions. And professional trustees do this all the time. If they're making a distribution of principal, they're going to put on their record, I had the power under paragraph yada yada on page 20 to do the following. These were the circumstances that were presented. This was my decision of what to do. And you'll keep that record because it could be challenged years and years from now. All right, Daniel, back to you.
And we always not scare the trustee, but we'll always just point out, what's the worst that could happen? And with these discretionary distributions, so again, these ongoing trusts for a beneficiary, what if it's the beneficiary themselves saying, give me the $100,000. I want it and I'm not going to sue you. Don't worry about it. I want it, or I don't want this trust for my lifetime. Maybe it made sense at the time, but things have changed. I'm more mature. I can handle the inheritance. Even though the trust says it goes on till I'm 50, let me just have it all the money right now. And the trustee could be liable to that beneficiary for giving them too much money. And so the beneficiary themselves, especially if there was a good reason why it was held in trust, and they blow the money that you gave them. So you gave them the 100,000, they blew it. Now they're upset at you for giving them the money because technically it is a breach of trust. You weren't supposed to give them the money, And even though they asked for it, you gave it to them, they could still sue the trustee for giving them that money. And a couple of questions in the Q&A regarding like the duty of notification in the period to contest the trust. So right, most trusts, you'll notice, have language that says if there is a contest, maybe that beneficiary could lose out on what they were supposed to get. So we call it a no contest clause. Because again, if they're objecting to the trust, they lose out, they get nothing. Well, in those no contest clauses, really, that would apply if a beneficiary really objects to the trust and had no reasonable basis to do so. So that would have to be kind of a situation where maybe they didn't really even speak with an attorney, they just fired off a lawsuit, they're objecting to the trust. That could trigger the no contest clause and they could forfeit their share. Other times, if they're objecting to the trust and maybe they work with a sophisticated attorney, they're going to find ways to object without triggering the no contest clause. Normally, that's if they're saying, the trust we're objecting to is invalid on its face. So it doesn't matter if there's a no contest clause, the whole document is invalid. Why would it be invalid? Maybe when the person signed it, they were incapacitated, so they were, unduly influenced by someone in the room to tell them what to say and sign. Or again, they just didn't have the capacity to understand it, and so the document itself is just invalid. So there's ways to object to a trust without triggering that no contest clause. And then getting back to the idea of who are your heirs. And so in California, let's say I'm single and I have children. My heirs are my children, and that's it. It's not my parents, it's not my siblings or nieces and nephews. It's just sort of the next direct lineal descendants in that case. What if I'm single, but I don't have any kids, and maybe my parents are alive? Well, now they are my heirs. What if I'm single, my parents aren't alive, but I have siblings, my siblings are the heirs? So it is, in a way, sort of like the next of kin. And it could be that somebody has lots and lots of heirs if they have, sort of like no, not married and no children, and things just going to go up to like cousins and things like that. Their heirs could be somewhat numerous. And that comes up, unfortunately, in certain probates that we handle, where let's say someone passed away and again, they didn't have a will or a trust or anything, and now some family members coming in, we have to come up with a family tree to see who are the heirs. And it could be very far out. We're dealing with like probates where it's like the second cousin once removed gets 1/27th of the estate. And you can even hire these heir finding services to come up with these family trees. And so, yeah, the heirs could be an issue too. Okay. Um, Back to, again, the trustee's duties. And we talked about the standard of care to act as a prudent person. So now we're thinking about the assets of the trust. So this has nothing to do with the beneficiaries or anything. It's just the trustee is now managing the assets of the trust. And the trustee is held to this prudent, kind of the fiduciary standard to act as a prudent person was. Meaning, again, if it's my trust, my assets, I could be as speculative and as risky as possible. But when the trustee comes in, they have to completely kind of rethink the whole thing. One, we always think, well, what is the time horizon of managing the trust assets? In the normal situation, if it's, I die, trustee takes over, liquidate everything, get it all distributed, again, maybe 6 months to a year. So the trustee isn't necessarily going to try to invest and grow the estate within the 6 months. They're really trying to preserve what's there. Really, they're always trying to preserve what's there. Because again, if the trustee has a little bit of a risk portfolio of the trust assets and the value goes down, they could be sued personally or and kind of for the loss that they incurred if it was found that they sort of breached that prudent investor rule, meaning it wasn't, diversified, they were too concentrated, they just didn't take into consideration market volatility. Speaking of volatility, again, it's nice when you're a trustee when the market's going up because you have, less concern for risk because everything's going to go up no matter what you do. Now, especially this year, again, there's potentials for lots of volatility. And so we're very conscious of that, of the market. When, someone passes away, the trustee comes in, either work directly with a financial advisor or let's just take a look to see how the assets are set up. Sometimes it's surprisingly risky for like a 90-year-old person to have, all these equities and things like that. And so we'll say, let's meet with a financial advisor and come up with a better plan, maybe diversify the assets. And there's always these situations where somebody comes in and it's mom and dad, their entire wealth was generated from mom or dad working at some tech company or Exxon Mobil Gas or just a lot of engineers that work in these startups and have all these stock options. but that's sort of a concentrated value of their estate. It could be, other than the house and maybe some cash and things, they could have millions of dollars, concentrated in just one stock, because that's, who they worked for and that's how they kept it. When the trustee comes in, they don't really have the ability to continue to maintain that, even if it's almost like a family heirloom to continue to own these stocks. However, if the trustee really doesn't want to, get out of those positions and they like the idea of being able to pass along the actual stocks that the parents had to the kids or whoever it's going to go to, there is the process of the trustee getting consent from the beneficiaries. They have to be informed about this is what's going on. These are the assets. There's this concentrated holding, and you're consenting to allow me to hold on to it. So even if that one, stock goes down and it seriously affects the value of the estate, you're not going to sue the trustee. So the trustee does have some abilities. Again, that's our role in advising the trustee, is to minimize their risk.
Well, compensation of the trustee, very important to pay attention to this. I said it before, we have to look at the terms of the trust. What does the trust say about compensation? Because we have to fall within the trust guidelines. Many trusts say reasonable compensation, or if it doesn't say, the probate code says it is reasonable compensation. So let's say I have a trustee who's an engineer, and the engineer says, can I charge my usual hourly rate for all my work on the trust? And I would say, no, we have to decide what are your services and that you're compensated for the type of services you're doing. So if you're going to clean out the house, you would be compensated what a housekeeper might be paid for those services. If you're deciding, does a new roof have to go on the house? Well, maybe you should be compensated as an engineer. And if it's an engineer, I can say, would you please create a spreadsheet that shows your time diary of everything you've done every day, how much time went into it, and then create categories. Was it housekeeping? Was it accounting? Was it deciding about a new roof? Was it meeting with the broker? Something like this, all your time, and then assign a reasonable hourly rate to each of these skills. And then we have a really defensible spreadsheet for what should you be paid as trustee. That's what a court would look at. And they also want to see what was the benefit to the estate or trust. Were there multiple beneficiaries? Because the court knows if you have to talk to 10 people all the time, that is a big job. Many times professional trustees are paid a percentage of the trust, maybe 1% per year. But again, a court will always look at what did you do and what were the value of your services. And also the beneficiaries, they have no idea how much time goes into being a trustee. It's just incredible. They just see, well, a couple months later, this happened and this happened. They don't know how hard you're working. And so it is good to have that time diary.
And I'll
Daniel,
say that
back to you.
that is, unfortunately, one of the more frustrating components of administering a trust is the trustee compensating themselves. And so, unfortunately, what happens is normally the trustee will take like the fee at the end. So if it's just, again, normal trust administration done within 6 months to a year, the trustee will just take that one fee off the top before doing the distribution. And that's where they're going to get the most pushback, again, from the beneficiaries that don't know what it takes to administer a trust and how much time is involved. They think, oh, you're just, you're one of the kids, or mom named you, could have named any one of us, and none of us should take a fee. It's just an honor to do it or something. And I'll say, it's a lot of work to be a trustee. There could be hundreds of hours put into it. And even in the beginning, we'll mention, the trustee, you're entitled to take a fee. Sometimes they'll say, okay, don't worry about it. I'm not going to take a fee. I'm doing it because I'm supposed to do it. And then a few months go by and they say, okay, how much was that fee I can take? And what's a reasonable amount? And so just because it's a lot of work that you may not know, especially if you have your own life and it's very interruptive in your life to be a trustee. And that's where, again, the beneficiaries give a little pushback, unfortunately, and you feel like you've done all this work and now they're fighting you on just something that could work out to minimum wage if you did it by the hour type of thing. Okay. Whew. And so, thank you for everyone for sticking with us through our presentation about the trustee's job. And again, if you haven't really, after going through all of this, you don't feel comfortable with who you've named, knowing what they might have to do, that's a great time to meet with your attorney to maybe consider revising who the list of the trustees are. Again, there are professional trustees that exist, and there's actually a rule nowadays that they have to have their like fee schedules posted online. So that's always a big question we get is what does the professional charge? And for one, it doesn't cost you anything to name them. So they're not acting as the trustee just by being named in the document. But let's say they actually become the trustee, they have like a set fee schedule that you can look at. And you can always verify their license and everything. And so a lot of people that don't have maybe someone personally in their life that they feel comfortable naming, there is that option. And again, uh, if you are named as the trustee, it's a great idea to just get advice from an attorney, especially in the beginning. I know some people think they should, trying to keep the cost down and just take care of it themselves, but there's just a lot of pitfalls. And again, with all the duties we talked about, it can take a little bit of help to, properly do a trust administration. And you don't want to make any mistakes that could cost a lot of money to fix afterwards. And again, just to know you always have the ability to change who you name as the trustee. So again, while you're alive and you have capacity, just because you name someone today doesn't mean you can't change it in the future. So again, for some people that have like younger children, maybe they'll name like a parent or a sibling as the trustee, and then the kids get older, they can change it and hopefully name the kids at that time. So that's always something to keep in mind that you don't want to, not have the best people in there, hoping that it'll work out in the future. Again, same kind of concern if you have co-trustees in there where, again, we'll get the situation where, the clients get in there and say, oh, but just name like the two kids or all three kids as co-trustees. And we say, well, if it happened today, how would that work? Could they all agree on selling the house or what to do with this? And again, if one of them's living in the house, would they all agree on what the plan would be? And sometimes they were saying like, oh, they can't even get in the same room together now. And then how are they going to do it when they have to actually get down to business? And unfortunately, isn't always just the co-trustees that are acting that might have a little bit of input. There could be their spouses. So that's another thing we will kind of bring up practically to say whoever you're naming as trustee, could they be influenced by their spouse to do something maybe they shouldn't otherwise? And does that create some future conflict as well? So these are all the things we have to consider when naming a trustee. And again, with working with an attorney to advise a trustee and following all these duties and responsibilities. And so here's all of our contact information. And if you have questions, call or email. If you'd like to set up an appointment to review who you've named as trustee, you can always reach out to us and we'll review your documents. Again, whether we prepared them or another law firm prepared them, we can review your documents. And as far as after the session goes, you will receive a link to watch it or share it if you like, along with the slides and the handout as well. And so again, we appreciate everyone joining us today and hope that you have a great day. Thank you very much.
Thank you.